Well, good afternoon, and welcome to the 8th installment of Lawyers and Friends. My name is James Cousins, an attorney with the law offices Melissa Day, and I am the friend today to attorney Paul Kornacki.
Good afternoon, everybody.
Before we get started, I just want to give our basic disclaimer that this series is provided for informational purposes only, and that nothing we say herein, as much as it may sound like it, constitutes legal advice or creates an attorney-client relationship, although most of you good people have already decided to use us to represent you in claims. So we're hoping to provide you with some entertaining banter today on a really interesting topic. Paul, idiopathic injuries. I don't know about you, but I'm kind of jaded, so when I hear that phrase, I just think of the word idiotic injuries.
Idiopathic injuries. You're going to see this at least once or twice a year. Everyone has done it. They're kind of maddening. For example, I was walking to my desk and I felt a pop in my knee.
Oh, you're fired, Paul. That was not work related.
How can that possibly be compensable? I was walking to my desk and I fainted and I fell to the floor. How can that possibly be related to my work?
Were you reading a board panel decision at the time you fainted? That could be a cause that is related to your employment.
So these injuries, it's an unexplained injury. It's not I tripped on the carpet. That obviously has an explanation. I slipped on a wet floor. That has an explanation. This is just something that it seems completely unexplained and unrelated. And yet you have to defend these cases fully.
Right, and when we get to the end of the presentation, Paul, when we bring this all together, there's some interesting things that we're going to talk about whether idiopathic in the truly definitional sense, like if you pick up the Webster's dictionary, is really what this means. But as with all things in comp, we got terms of art and we've got board panels who use terms interchangeably. So I guess we'll get to the finer nuances after we hear some cases.
We'll do that. And let's just get some of the ground rules. Of course, the claimant enjoys the presumptions under Section 21.
And they really do enjoy them, right?
And they really do. Section 21(1) creates a presumption that absent substantial evidence to the contrary, an unwitnessed, unexplained accident comes within the provisions of this chapter.
That seems to just fall like right on point, right? Unexplained. So is it that do you think we have to really explain this stuff to win? Or do we just think we have to prove that it was unexplained and we maybe get something else?
Well, it is really up to the carrier to provide substantial evidence to overcome that presumption. And that's going to be the key to surviving these types of cases.
So it's not just hitting on one point. We're going to have to hit on all cylinders, really, like a normal case.
And we're going to have to look for evidence either from an eyewitness testimony or from the claimant's testimony or from some medical evidence to try to provide an explanation, an alternate explanation.
All right. So what cases do you have for us?
And before we go on, we're also going to, let us not forget that the claimant, if we have a completely unwitnessed accident, which is idiopathic in nature, the claimant's still going to have to come forward with some credible evidence.
So they got to check the box, right? So this is that case law that we always see where it's like the presumptions aren't a substitute for proof; they're just a plus. They're like they're taking their steroids. It's the steroids for the proof. They got to have something, right?
They got to have something to go forward first. So they're not the presumption can't be relied on wholly. They're still going to have to come forward with some evidence that this accident actually occurred, and you're going to have to be credible.
Okay.
So let's go to some cases and see what you think. I
feel sorry for the coffee. That's the part that makes me most upset about that picture. That's a waste of good coffee.
Case number 1. On March 7th, 2016, he was going up steps at work and felt a pop on the second step. There were only two steps involved in this case. He injured his right knee. He notified his employer. He returned to work. What do you think, James? Compensable or not compensable?
Well, I have a bad habit of saying nothing is compensable, but I'm not sure. So there were steps involved, and he felt a pop. Did the claimant have any decent medical evidence? I mean, what do you think?
In this case, his own doctor testified, indicating that there are traumatic tears and there are degenerative tears. And that in this case, the claimant likely had a degenerative tear, which typically happens after age 40, when the meniscus becomes less elastic.
I like that testimony. I like that testimony a lot.
The law judge established the case.
Oh.
However, the court panel overturned.
Oh my God.
And found this case not compensable.
The board panel reversed.
The board panel reversed. The case is not compensable. And they found that utilizing the claimant's doctor's testimony, that was sufficient to rebut the presumption under Section 21.
Right, because then the claimant's proofs really don't. I mean, I guess you could also say the claimant's proofs really didn't stack up, right? Because the doctor provided an explanation that was credible. And if we presume that what he says is true, it's a degenerative tear.
And it was his own doctor.
Yeah, that's nice. That's nice.
There are ways to defend these cases with a thorough cross-examination of the claimant's doctor.
Right, and that's I guess that's a practice point I want to touch on. It's these cases. I mean, they do sort of look like your basic case, right? If we didn't sort of add in this theory of idiopathic defense, which is just essentially, right, the idea that we have an injury that simply doesn't line up to the mechanism that's claimed. So the claimant's coming in and saying either something really lame happened or nothing happened at all, but there's a serious injury. So I guess exploring that in more detail is probably what's going to define these cases and make them different from sort of your run-of-the-mill claim, which is how on earth could walking up a step cause an injury? And I also think it's interesting too, I guess later on we're going to talk about instrumentalities. So there were stairs involved here. I guess stairs may not be an instrumentality.
Stairs may not be an instrumentality in this case. It was simply an unexplained accident.
Okay.
Let's go to case number 2. The claimant testified that October 2013, she had finished cleaning the bathrooms in the gym. She was walking with a coworker, and I just felt a pop in her right foot. The claimant testified that she reported it to her supervisor and went to the emergency room that night. The claimant testified that she was walking across a flat surface when she felt a sharp pain. Compensable or not compensable? James.
She's walking across a flat surface. She had been doing work, but that didn't cause the injury. She stopped doing that work. She's presumably walking to do some other work. Sharp pain, there's no instrumentality. There's nothing related to employment here except for walking, which, by and large, we all do for our jobs. I say not compensable.
An IME suggested that she may have had a metatarsus deformity, and this may have put some physiologic stresses on her forefoot and may have caused the stress fracture.
I mean, I'm okay with that. I don't like the word may. What did the board do with this?
The board found this compensable.
Okay.
The carrier had failed to rebut the presumption under Section 21. There was not substantial evidence to the contrary. It occurred during the course of her employment, and therefore it was compensable.
So so the medical wasn't enough on its own, and the walking on a flat surface was deemed to be an instrumentality. That wasn't one of our cases, was it? That's not one of ours.
That's
Not.
not.
You know why it wasn't? Because you know what? Oh, I just dropped it. I found a case that was ours. Right here for a second.
Jump right in here.
So I've got a 2015 claim that I was looking for because when you and I talked about this case, it was just maddening to me that on those facts you get a compensable claim. So I've got a December 2015 panel decision, G093-1735. So we have a claimant on his first day of employment. He's being trained and he's shadowing the person whose job he's going to be trained to do. They are walking down a hallway and he felt a pop in his right foot. It's kind of funny, there's some typos in here of course, but it says the claimant yelled out and indicated he felt something pop in his right foot. The claimant advised him that he had a similar right foot injury in the past. We litigated this claim fighting vociferously on a theory of legal idiopathy. That is to say, like, we didn't get an IME, we chose not to get an IME because the medical really didn't do very much in this case. And the claim was disallowed by the WCLJ, and on appeal, the board panel says, and this is the language I guess I want to get to because we're going to hear about it later, I think. In the instant matter, the claimant failed to identify a distinctive feature or risk incident to his employment that caused or contributed to the claimed injury. The claimant admitted he was merely walking at the time of the occurrence of the injury. That merely walking thing actually made it into a couple appellate division cases that are often cited here. Significantly, the claimant had an incidental prior injury to the right foot and had treated that morning for an unrelated condition of the left lower extremity. Absent from the record is any evidence that a work activity caused or contributed to the onset of right foot symptoms. In fact, the claimant admitted that during the training week he was not performing any of the duties of the job, but rather was shadowing another worker to observe the manner in which this other person performed the job duties. This is borne out by the fact that the injury occurred while the claimant was merely walking, not performing any work-related duty, and with no work-related contribution to the onset of the injury. So the board panel affirms disallowance of that case. Paul, can you grab any distinction between what we won on and how this case lost?
In this case, there's no instrumentality. She was merely walking, as you noted.
Yeah, no instrumentality. There's none in this case either. And she had been doing work before, but she wasn't doing work when she was walking. And the decision that you cited really doesn't make a fact of like, oh, she was walking to do this place, or walking was somehow incidental or necessary to her job, because that's sort of accepted. I just really don't get it. I mean, the only distinction I see is that our claimant had a history of having a problem with the injured foot that he just testified to. There was no medical documentation of it, but we did have documentation that the opposite foot had some treatment for what the board even concedes was an unrelated condition. So, I mean, is the board saying in our case the claimant's less credible than this claimant, and that's why they disallow it? I just don't get it.
Seems like an excellent result on your part, because the case law would generally favor the claimant in that position.
And not wanting to toot our own horn, I think the other distinction is that we litigated one case and we didn't litigate the other, right?
We are going to move to the next example, James. The claimant filed a C3, setting forth that she was walking downstairs at work, felt a pain in her left knee and leg, and heard a loud pop. She could not bear weight on the leg and had to hop down the rest of the stairs. Oral and written notices were given to the employer that day. The accident occurred as the claimant was leaving work for the day, but still on and inside the employer's premises.
Oh.
James, compensable or not compensable?
Oh, there's okay, so there's kind of a red herring here, which is the premises issue, right? So, I mean, I think we would definitely defend this case on a premises issue, but the claimant's still inside it. She's walking downstairs. All right, so the first case, we had stairs involved, and the board didn't think that those were relevant in that case, right? This case, we have stairs. I'm going to say not compensable.
The IME, Dr. Nunez, diagnosed the claimant as a soft tissue trauma to the knee with possible torn meniscus. The doctor described the mechanism of injury and indicating that it could easily have caused the above presumptive diagnosis.
But it's a presumptive diagnosis. If you can't tell me what's wrong with the claimant, how can you tell me what it's related to? That's one of my favorite questions to ask.
And this case was found compensable.
Oh, that's terrible. Walking down the stairs. Okay. So stairs may play a role or may not play a role.
The board did notice that this was after work, but it did indicate that she was still on the premises and therefore was still covered. And regarding the idiopathic injury itself, they found that there was not substantial evidence submitted by the carrier to overcome that presumption under Section 21.
So this case really turned on Dr. Nunez's IME, saying that it was possible that whatever was wrong with her was caused by the act of walking down the stairs.
And even though there was really nothing related to her work itself, it occurred on the premises and therefore compensable.
Right, but I mean, couldn't the board have come in on this case and said the claimant failed to identify a distinctive feature or risk incident to the employment that caused or contributed to the claimed injury? I guess maybe this case was just because the IME suggested causation, you're going to lose, huh?
And there's really no instrumentality involved here again. It was just simply walking downstairs. I felt a pop. So
and they didn't turn this decision on the stairs, right?
We didn't get to the point of discussing whether instrumentality was involved.
So they just resolved it on medical.
They just said it's not overcome and therefore compensable.
Okay. What's next? How many did I get right?
Goodness.
This is like those
So
NPR
far.
news quizzes. I'm going to fail.
I think you've gotten them. I think you got one right, James.
I got one right, 1 out of 3. I'm not going to get Carl Castle's voicemail as a prize at the end of this.
Well, we'll give you one more opportunity, James. At the hearing held on April 7th, 2017, the claimant testified that he fell from a standing position. This has got to be an easy one, James. You got to get this one right. He fell and hit his face on a piece of metal that was on the floor. The piece of metal, which protruded from the floor, was about 20 inches high and 40 inches long. There were about 4 or 5 co-workers that witnessed his fall. The claimant injured the right side of his nose and his left wrist. He was taken by ambulance to the hospital, and his nose and left wrist lacerations were stitched. On cross-examination, the claimant testified that he was probably drinking over the prior weekend.
Yeah?
He had a withdrawal seizure about 4 or 5 years ago. He does not know why he fell.
Right.
James,
All right.
help me.
So, first, before I answer this question, I need to know how it is that you're not sure that you were drinking over the prior weekend. How is that possible? Is it that you drink so often, or that you drank so much that you have no recollection of it? And he has a history of seizures. So the claimant is telling us in testimony, he's not saying it outright, but he's suggesting that he probably knows why he fell, right? So it's maybe not idiopathic by definition, but it doesn't have anything to do with his employment. I mean, unless he's a comp lawyer, that could drive you to drink, right? So I could see him drinking
He
because
was probably drinking. He's not entirely sure, but he thinks he was.
All right, I'm saying this is not compensable because, I mean, not only is that not work-related, that's so outside the scope of really any employment that, I mean, how could the board possibly encourage that behavior by finding a claim compensable?
The medical records were obtained, and the principal diagnosis was a drug seizure withdrawal.
Drug seizure withdrawal. Oh, man. Okay.
Secondary diagnosis was a facial laceration and a nasal bone fracture.
So he admits to possibly having an alcohol withdrawal seizure, hoping that we wouldn't find out that he was doing drugs and had a withdrawal seizure from that.
So he fell from a standing position. It looks like he simply...
All right, I still think, I say
Passed out.
definitely not compensable.
And this one is compensable.
Oh, okay. Compensable? It has to do with the metal, right? It has to be that piece of metal sticking up out of the floor.
So we know why he fell. I mean, we suspect that he was going through withdrawal, drug or alcohol withdrawal, and had a seizure.
Okay.
However, because he struck his face on the way down, the case was compensable.
Oh, so this is floor versus anything else case? Like if you hit the floor, we're good, and if they hit something else, we might have to pay for it?
They reasoned that while the claimant's fall was idiopathic in nature, the reason for the fall is not what is being claimed as being compensable.
You know, and while you say that, like that, I just want to bring this point up, because I looked this up. We talked about this earlier. The definition of idiopathic is relating to or denoting any disease or condition which arises spontaneously for which the cause is unknown. So this really isn't idiopathic, is it? I mean, we know what the cause is.
We
He
know
had
what the
a drug
cause
seizure.
is, and yet it occurred during work, during the course of his employment.
Oh, okay. I don't like that one. So I guess that 20-inch by 40-inch piece of metal. I mean, how could we possibly write coverage or as a self-insured employer set aside funds to insure for that kind of risk?
The resulting injury was caused by a risk incidental to the employment, whether that risk be great or small, unusual or extraordinary. In this matter, the claimant struck his face on a piece of metal, and while the risk may have been unusual and small, that does not negate the compensability of the accident, due to the fact that the piece of metal was on the premises of the employer and incidental to the claimant's employment.
I feel like this is an ironic use of incidental. Like you and I think of incidental in sort of the har, this is funny, this is a really remote issue, and the board is like, well, we're going to take the very strict definition of anything that's on the premises is incidental to employment. I mean, what on the premises is not incidental to employment? Are we going to get anywhere with figuring that out? I don't know.
We are not.
I mean, at least we have a suggestion that maybe stairs are incidental. I don't know. What's the next case? Is it going to help us at all?
No, it's not, James.
Oh.
So I guess the lesson for claimants is if you're feeling faint or if you're having a seizure and you fall,
Make sure you
aim for a table
aim for a
to
table.
make the case compensable.
Oh my God. Or catch if you're an employer, catch the person when they're falling, please. We're going to have to I don't know what we're going to do. I guess the only thing that might come out of that case that would be positive would be the employer knowing what sort of employee they're dealing with, right? I mean, that has to violate a work rule. If you're so ill or you're taking drugs that impact your work employment, maybe that's how the employer reduces that risk incidental to employment, is that employee no longer works for the insured.
He was an accident waiting to happen.
Yeah, a weird accident waiting to happen that was ironically incidental.
Next case. The claimant testified that he was working for the employer of record as an operating engineer. His job was to maintain, weld, and service machines. On the date of the accident, he was not feeling well, and he fell at the job site. He fell and struck his nose and had a cut under his left nostril. He testified that he felt dizzy and lightheaded. There was no evidence that he fell for any reason related to work. The claimant did not trip on anything, get his leg cut on anything, or anything of that nature. However, he hit his face on the curb. This occurred right after lunch. He was right in front of the gate going into the job site. He was already in that area that the public had no access to.
All right, so the locus of the accident, the location, is, I think, a red herring, right? Because he's in the employer's premises, and he had finished lunch. He was done with lunch. All right, so case number one, we had two stairs that are that cause an accident, or that are the potential instrumentality that didn't count. That case was idiopathic. That's the only one I've gotten right so far, apparently. Yes. So I'm going to say two steps isn't. I'm going to say one curb is not either. This is not compensable.
The law judge agreed with you, James. In this case, after the hearing, the law judge found no connection between the fall and his work duties and disallowed the case.
Nice.
However, the board panel reversed.
Oh, it's board panels. Okay.
The claimant, once he fell, struck his face on a curb on the premises of the employer and suffered injuries to his face and nose. As case law states, the claim may still be found compensable if the claimant shows that the resulting injury was caused by a risk incidental to the employment, whether that risk be great or small, unusual or extraordinary. In this matter, the claimant struck his face on a curb, and while the risk is small, it does not negate the compensability due to the fact that the curb was on the premises of the employer and incidental to employment.
But it's incidental in the ironic sense, like it just happened to be there. It's not like maybe a piece of metal that inures some benefit to the employer, right? Or a desk or a chair. Like the fact that there's a curb there.
I don't think he used the curb in his work, but nevertheless, it's there, and they consider it incidental to employment.
So all employees should just work in padded rooms. We should get those like automatic. What are those things like when you fall down a mountain and you pull the button and it's supposed to protect you from
from the avalanche.
Yeah, from the avalanche, where it's just like it deploys a sphere around you. We'll have to give those to employees, so when they faint, they just sort of come into their bubble and are protected. Okay, well I'm having a hard time seeing a pattern here.
We have another case. This is not a slide, but I'll give you the basic facts. This was a security guard while making his usual rounds at the employer's plant. He wanted to go up the stairs, and then he was coming down the stairs, and he, quote, something snapped in his knee. He stopped working and sought medical treatment at a hospital. Thereafter, he filed a workers' compensation claim. Compensable or not compensable?
All right, so we had two claims already with stairs. 2 stairs up, not compensable. Stairs down was compensable. I'm going to go with not compensable.
Okay, the law judge found this as a compensable work-related injury and awarded benefits. The board panel reversed, determining that although the claimant's injury occurred in the course of his employment, it did not arise out of employment. By the way, this guy had a prior injury 13 years earlier.
Was it weak medical from the claimant?
The appellate division reversed the board.
The appellate division reversed the board?
And established the case. To rebut the presumption, an employer must present substantial evidence to the contrary, which as a matter of law precludes the board from crediting any explanation of the accident except that offered by the employer. So the appellate division reversed the board, saying that there was not enough substantial evidence to rebut presumption under 21.
said we just had enough to sort of counteract it, but not to overwhelm it.
That looks like the case.
Oh my God. Okay. So it looks to me like we're starting to develop a pattern that, I mean, we know some elements, right? But it's a balancing of all of them in this case, huh? Or at least so far. Because stairs seem to be an issue that goes both ways. We have some instrumentality issues that I think we can resolve, fairly definitively. But it also seems like the medical can play a role pushing it one way or another.
Medical seems to play a role to a certain degree. Again, some of these cases do not have an instrumentality, some do. So you have to look and see if that's a factor in your case or not.
And we had at least one case where there was I think we would all agree the stairs seem to be an instrumentality, right? The board has said that they were in one case, and then the appellate division said they were in another. But if you got good medical, you may be able to say that instrumentality it doesn't become one, maybe? I don't know.
Let's go to the next slide, please, Najee. Yeah, the fainting case. And the next slide. I guess that's what we're talking about here, James, is the cause of a fall versus the cause of the injury.
Right. I mean, okay, so the definition of idiopathic means entirely unknown or just arising without any known cause. So, but in some of these cases, we have known causes of the fall or of the event that precipitated the accident, right? We had a drug seizure. We had some people who fainted.
Apparently had the flu, just didn't feel well, and fainted.
Right. I mean, I just defended a case a few months ago where the claimant had fainted as a result of dehydration. So it was documented in the ED record or the ER records when he came out. Said you were dehydrated, and he passed out. And the judge found that there was no relationship. No, that was an idiopathic cause, but it really wasn't because we knew what it was, right? So then the injury itself, so it's not just, okay, so you're like falling to the ground, then we have to, or something's happening that's idiopathic, and we have to figure out whether that then caused the injury or not. I mean, it seems to me like there's also, the medical plays a role in this, even though we have these two distinct elements, because medical could overcome the idiopathy. Is that even a word? I don't know. I'm coining that a word if it isn't already.
We'll make it a word today.
It's a word. All right. But if you have good medical, you might be able to get out of a case with an instrumentality like the stairs in that first claim. But if you have lame medical, you might lose a case where you have absolutely no instrumentality, like the walking along the floor, right?
These cases are going to be frustrating for case managers because it seems so simple, and they got to be thinking, how can this possibly be compensable? But they really are in many, many cases.
It's really, we're fighting the presumptions.
We're fighting the presumption.
We're fighting the presumptions, and it seems like we're fighting common sense to some effect too. I mean, a lot of these claimants must not believe that they could be related to their work at all, but because there's just no rational basis to conclude that anything their employer did, said, or I guess played any role. But the board is willing to charge an employer with liability for putting something in their offices, right?
Yes, exactly.
So like if I pitched forward in absolute horror from everything that happened here and I hit the table that the camera's standing on, that's a compensable claim because we put the table there. But if I just hit the ground, it's not compensable.
Could be.
Unless I push the point that the reason I pitched forward was I was in absolute disbelief at some of the inconsistent decisions the judges could give us and the board could give us, and apparently the appellate division too. Right? Because the appellate division's ruling on that staircase would seem to overrule the first case with the stairs, right? Because they were just basically saying there's an instrumentality employment. Or the case with the curb would overrule the case with the stairs, because the stairs were almost completely ignored as an operative fact in the first case, but the curb became an important operative fact in the latter case, just because he hit it. And in both cases, there was absolutely no link between the cause of the fall and employment. It was just, well, you hit the curb, that's it. And in the first case, there was no hit, there was no strike. It was just the act of walking up or down the stairs caused the injury. So I feel like this is, like what I'm taking from this is that this is like a totality of evidence. You have to generate a good case on all fronts.
Just walking across a flat surface, causing a stress fracture, can be compensable.
Oh my God. All right. Well, it's been a disheartening afternoon, I guess, but there is some hope. That is definitely not idiopathic because she always pulls that.
That could be a
football.
horseplay.
Yeah, that's definitely a horseplay.
Could be a horseplay.
Yeah, and I'd write her up for that. I'd write her up because that would make the case better too. Get the discipline in the record. She pulled the ball away. He looks like he's going to hit his head. That could be a closed head injury case too. I hate those cases. Well, we wanted to get you guys out a little bit early. We know that the long holiday weekend's coming up, and we're going to take some questions now. Maybe Najee can put us through live, or maybe Najee, you can read them to us. What's the question we got?
I will read it. Leah Zikari says, why would carriers get IMEs when these issues can be argued purely on legal issues? Is just walking compensable, or when there is no mechanism of injury related to work activities? These IMEs will bury us every single time when there is no evidence pointing to another cause. Doctors don't know anything about legalities. They only know medical diagnoses. What say you?
Well, because they know nothing has never stopped a doctor from having an opinion on something, right? Okay, so the case that I read that was our office, we didn't get an IME, but there were two solid facts that were already ascertainable on the initial investigation. One, the claimant had already said that it was a perfectly flat surface, right? So if you call me and ask me a question about compensability, we're going to first ask about instrumentalities, right?
Yes.
Is there an instrumentality? So if we don't have an instrumentality, then the next question we would ask is, what does the medical from the claimant look like? So if we have a doctor on the claimant's side who's I don't want to say wishy-washy because that's not fair, who's rational. So if we pick somebody like who's rational on cross at least.
Dr. Grant.
No, that's not true. Schler, right? Or Bagnall. Somebody who is going to give you at least an honest answer, and you think that you're going to be, and maybe the medical records already suggest that like it's a degenerative tear, not a traumatic one, or the doctor's already commented that, that in some way that leads you to believe that the act of walking or up and down the stairs or whatever it happens to be is sort of an absurd cause. That case, I would definitely take the risk and not go with an IME. But if you have Grant, who likes to be judge, jury, and executioner, and who's going to give a strong written opinion and be kind of mean in his testimony, well, he's a jerk in his testimony, then I might go ahead and get an IME, but I would carefully select the doctor, right? And because then we would, almost, wouldn't you agree, Paul? These cases suggest to us that we would need an IME to prevail.
I think there's a presumption in favor of the claimant. You got to look to try to rebut that presumption. You got to look for some medical evidence, and an IME might help in that case.
Right. So if we know we're stacking up against an aggressive doctor, or at least an aggressive written opinion, we may want to get one in that case.
Because we might find there is a reason to explain why she fell or why her knee popped.
Right. I mean, there is always the opportunity. I mean, it is a risk. It's also, I think, in some cases, a co-equal risk to go without one. I think if we had a record with absolutely no mechanism and a wishy-washy, moderate, or even a fair doctor, I would recommend going without the IME and just defending it on a legal basis, like the case I cited. If we're looking at something strong or there is a possible mechanism, I think it's worth the IME because it's going to give you one way or the other, right?
Thank you for the question, Leah.
We got anything else?
That's it.
Hearing nothing further from the law offices of Melissa Day, I'm James Cousins.
I'm Paul Kornacki.
We want to wish you a happy holiday weekend. That's my This Old House version of the sign-off.
Things keep changing and never for the best.
We're off.
Not for you. Rearranging rules that we cannot contest. What can you do? Don't go crazy when the judge says your claimant had a good day. When things look hazy, 'cause there's nothing left of 25A. Don't get angry. 'cause you might